Special Prosecutor, an area in which I must admit to some considerable interest myself. I served as United States Attorney in my home state of Pennsylvania during the 1970s with a particular focus on cases involving government integrity, and then was the Assistant Attorney General in the United States Department of Justice in the immediate post-Watergate era in the Ford administration, during which time the Public Integrity section of that division was established, and during which period of time there was developing considerable sentiment for the office which we are discussing this evening. I must admit, in the spirit of full disclosure, to considerable uncertainty about the independent counsel's office, and I frankly look forward to learning from these gentlemen tonight as they exchange their views and I think share with you a desire to come to some conclusion about this unique office. Our panel is made up tonight of four individuals who have had considerable experience with this office. To my immediate left is Tom Boyd, Deputy Assistant Attorney General in the Office of Legislative Affairs in the United States Department of Justice. Tom is with us this evening as a designated hitter because his boss, John Bolton, fell and broke his shoulder. I accused John of going to great lengths to avoid an appearance before a Harvard audience, but in fact, he stepped off into space, I guess, Tom, thinking he was going down into another room, and in fact went downstairs, so we will send him an appropriate transcript of these remarks this evening. Our second panelist is an old friend of mine, Phil Hyman. Phil and I were classmates in college. He has had a distinguished career both here at Harvard and in the Department of Justice, joining the Solicitor General's office after a clerkship on the Supreme Court, and later serving as a member of the Watergate Special Prosecution Force and as Assistant Attorney General in charge of the Criminal Division. Is now here as the faculty of the Harvard Law School, with whom we share the sponsorship of this event this evening. Next to Phil is Gordon Krovitz, who is a graduate of the University of Chicago, a Rhodes Scholar, and obtained his legal education at the Yale Law School. He is now an editorial writer with the Wall Street Journal, but brings a considerable background in the law to that very important role. And finally, to my far left is Fred Wertheimer, President and Chief Executive Officer of Common Cause since May of 1981. Fred is a graduate of the University of Michigan and the Harvard Law School and was a fellow at the Institute of Politics here and has been with Common Cause since 1971. We are going to proceed this evening by giving you the opportunity to hear from two of our panelists on the policy arguments respecting the independent counsel, and then to focus a little bit on the legal arguments, and then we will hear from our panelists in a kind of a free-for-all discussion, and then give you, the audience, the chance to participate as we wrap up the evening. We want to thank you for joining us this evening. We want to thank the Harvard Law School for co-sponsoring this event, and I will now turn the discussion over to our first panelist, Fred Wertheimer. Fred?
Thank you. It's good to be here. Basically, my memories of Harvard really focus on the notion of coming here to law school as a freshman in 1959, and in my first week moving to the back benches of my law school classes and staying there for 3 years. So every time I come up here and have to stand in the front and answer questions, it violates all my best memories of being a law student here. In the spirit of full disclosure, I too am also going to mention that I firmly believe that this law is constitutional, and I'm going to leave it to Phil Hyman to explain all the reasons why. He is an outside counsel to Common Cause and has been on a brief we've filed. And I totally agree with everything he's going to say. I want to focus on the on the policy questions involved here, based on the issue of whether or not we should have an independent counsel system, assuming it is constitutional. The present statute was enacted in 1977. It was went into effect in 1978, reenacted in 1982, and just reauthorized again this year. In its simplest form, under this statute, when the Attorney General receives credible and specific information that a high-level executive branch official covered by the Act may have engaged in criminal conduct, the Attorney General must conduct a preliminary investigation. Following the preliminary investigation, the Attorney General must request the appointment by a special court of an independent counsel unless the Attorney General finds there are no reasonable grounds to believe that further investigation is warranted. Once the appointment is made, the independent counsel assumes full power and independent authority to conduct the investigation and possible prosecution. The counsel can be removed by the Attorney General only for good cause or mental or physical impairment. Those grounds, I'm sure, over the years may get subject to more and more interpretation if the controversy over this legislation continues. Any removal is subject to judicial review. Since I work for an organization that lobbied for the passage of this legislation in 1977 and for its reauthorization twice, and is filing an amicus brief in support of the constitutionality of this legislation, it's probably not going to come as a big shock that I believe this independent counsel system is an essential mechanism for our law enforcement system. But I want to point out something at the outset, and that is that it should be recognized that on the policy level, there is very strong bipartisan support for this concept. When the legislation passed the Senate this year, it passed by a vote of 85 to 10. The supporters for it ranged from Senators Kennedy and Biden and Metzenbaum to Senators Dole and Thurmond and Hatch. 34 out of 45 Republican senators voted for it, along with 51 Democratic senators. It has not been a partisan issue, certainly not a partisan issue in the Congress of the United States. In the House of Representatives, the legislation passed by a vote of 322 to 87. And Republican Representative Henry Hyde, who is well known as a strong and consistent supporter of this administration, in this particular case supported the legislation. And what he said during the committee markup, he's a member of the Judiciary Committee, is, quote, "I don't think administrations can effectively investigate themselves. The perception is one that some degree of favoritism would be present." At the heart of the issues involved here is a very basic question. How does a government investigate possible criminal conduct by its top officials, by the people, the government's most powerful individuals? How does a government investigate the possibility that criminality may have occurred? And there's one, I think, central point in this debate. Opponents of this concept argue that for both constitutional and policy grounds, it is wrong to have a prosecutor who is not ultimately subject to the President's or the Attorney General's control. Supporters of this law believe just the opposite, that it's essential for an independent counsel to have this freedom in order to avoid conflicts of interest and to have the capacity to conduct publicly credible investigations of possible criminal activities at the top of our government. Supporters believe the public must be able to conclude that there was no basis for suspecting that high-level officials may have been given preferential treatment in the enforcement of our criminal laws. and that the independent counsel system is necessary to achieve that result. At the time the law was first enacted, the House Judiciary Committee said the following, and I quote, "The Attorney General is at the same time the chief federal law enforcement official and a presidential appointee who is a key member of the President's cabinet. Cases involving possible wrongdoing by high-level executive branch officials, therefore, present a fundamental conflict of interest." Close quote. The conflict of interest here is an inherent one to the system. But history also tells us that the issue of the relationship between a president and an attorney general is not simply a conceptual one. Just in recent times, we've had President Kennedy and his brother as Attorney General of the United States. We have had President Nixon and his campaign manager, Attorney General John Mitchell. And we've had President Reagan and his longtime political advisor and aide, Edwin Meese. In taking control of criminal investigations of top public officials away from the Attorney General and away from the President, which is what this legislation does, we believe the law establishes a law enforcement process that is free from real or apparent conflict of interest, that is free from suspicion, that favoritism or special treatment is being given to top government officials, and that is publicly credible, both in terms of a decision to prosecute and a decision not to go forward with a prosecution. In order to have a practical sense of what's at stake here, we have to take a look at the present situation in this country. If you take this law away, this is what would be going on. The Justice Department would be presently investigating for possible criminal conduct a former top-level Justice Department official, Ted Olson, for activities conducted while he was at the Justice Department. The Justice Department would have been responsible for the investigation and prosecution of two of this administration's top aides over the course of the administration, the former Deputy Chief of Staff in the White House, Michael Deaver, and former political advisor in the White House, Lynn Nofsinger, both longtime political associates of both the President and the Attorney General. The Justice Department would be responsible for investigating possible criminal conduct by the White House, including possible criminal conduct by the former National Security Advisor, John Poindexter, and the former National Security Council staff member, Oliver North. The Justice Department would be responsible and would be in charge of determining whether any of its own activities in the Iran-Contra affair may have involved possible criminal conduct. And the Justice Department would be responsible for investigating the activities of the Attorney General of the United States. We believe there is no way that a Justice Department could conduct or control the conduct of such investigations in any publicly credible manner. And that without that kind of publicly credible investigation and possible prosecution, you do not have a system in this country that the public can feel provides even-handed and fair law enforcement. Now, I think it's fair to say that the present Attorney General of the United States is a controversial public figure. Last week, the President of the United States described him, along with Michael Deaver and Lynn Nofsinger, as the very soul of integrity. In some quarters, Mr. Meese has been recognized for distinguished public service. He's been held out as a kind of role model for government officials and students. Others have a different view. They consider the Attorney General and his record to be one of ethical insensitivity and a kind of case study for why we need the independent counsel law. Certainly no one in America has had more experience with the independent counsel system than the Attorney General of the United States. And after his first independent counsel investigation was completed, during his Senate confirmation process, Mr. Meese told the Senate Judiciary Committee the following. He said that an independent counsel was, quote, the only effective and fair way to determine the merits of the various issues that had been raised in his case. And in closing, let me just say that if this system was good enough for the Attorney General, Mr. Meese, it should be good enough for the rest of us. Thank you.
Thank you, Fred. As always here in the forum, there is another side, and Gordon Krovitz will address from the policy standpoint his views on the independent prosecutor law. Gordon?
Thank you very much. There is a saying among judges that any prosecutor worth his salt should be able to persuade a grand jury to indict a ham sandwich. The rules favoring prosecutors are based in large part on the notion of prosecutorial discretion, that prosecutors will be restrained from bringing frivolous or overly aggressive charges because they share some common guidelines of when to bring charges, what kind of charges to bring, and when discretion requires that they drop investigations altogether. It seems to me that one reason the founders gave the power to prosecute individuals, the government's greatest threat to individual liberty, only to the executive branch, is that prosecutorial discretion is possible only when federal prosecutors operate under the same authority and under the same rules. Civil libertarians should be aghast at the idea that a private attorney can be appointed to an unsupervised position where he has the power to bring charges that can put a citizen in jail. Independent prosecutors are thus a constitutional oxymoron. They are not supervised by the executive branch through the Justice Department, but by the judicial and legislative branches through a special panel of federal judges created by Congress just for the purpose. As a practical matter, there is no limit on resources for independent counsels. Their bills are paid by the Justice Department, no questions asked. As Rudolph Giuliani, the federal prosecutor from Manhattan, has pointed out, the normal federal prosecutor has several investigations going on at the same time, whereas the independent counsels must make their reputations, if they are to make reputations, on only one investigation. This creates the nightmare world of unhinged prosecutors. In 1940, well before the creation of independent counsels, Attorney General Robert Jackson, who was later a Supreme Court Justice, warned that the greatest danger posed by any prosecutor is that, in his words, he will pick people that he thinks he should get rather than cases that need to be prosecuted. For with the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. In such a case, it is not a question of discovering the commission of a crime and then looking for the man who has committed it. It is a question of picking the man and then searching the law books or putting investigators to work to pin some offense on him. Worst of all, Attorney General Jackson concluded, is when the real crime becomes that of being unpopular with the predominant or governing group, with being attached to the wrong political views. Indeed, the entire apparatus of independent counsels is a violation of separation of powers. The reason the Congress supports independent counsels is because it usurps executive functions. In the case of the past 7 years, independent counsels have been used by a liberal, democratic Congress for the sole function of harassing the officials of a conservative, Republican executive branch. There is not supposed to be prosecutorial discretion. Instead, the Ethics in Government Act is fundamentally a tool to boost Congress in the never-ending battle over separation of powers. My predecessor mentioned the case of Lynn Nofsinger. Lynn Nofsinger was recently convicted by an independent counsel for lobbying before the end of a one-year ban on executive branch officials lobbying their former agency. In contrast, congressmen, the day after they leave office, can and often do become lobbyists and are even given access to the floors of the houses of Congress to facilitate their influence peddling. The 4 independent counsels currently in operation have more than lived up to their function as persecutors of executive branch personnel. Lawrence Walsh perhaps best exemplifies the dangers in entrusting the government's most lethal power over individuals, the power to investigate and bring criminal charges, to an unanswerable prosecutor. He has won guilty pleas from 2 fundraisers for the Contras, Carl Channell and Richard Miller, for activities that were not tax crimes. They pleaded guilty to using their charitable organization to raise funds to buy arms. Yet spokesmen for both the Internal Revenue Service and the Tax Division of the Justice Department have since said that this was at most a civil violation, not a crime. No one knows what pressures Mr. Walsh applied to get the guilty pleas to non-crimes. Mr. Walsh did offer some insight into his philosophy in a speech this past summer to the American Bar Association. He said that he felt he had a duty to prosecute if he had probable cause to believe that an offense had been committed. This is a far lower standard than the Justice Department guidelines for federal prosecutors. These guidelines say the probable cause is merely a threshold test. Other factors, such as the likelihood of a non-biased jury convicting, are also supposed to be considered. Another requirement is mens rea, the Latin phrase meaning the requirement for an evil intent to do an evil act. Executive branch officials, such as Ollie North and John Poindexter, who believed that they were carrying out the authorized activities of their commander-in-chief, do not, it seems to me, have the mens rea needed for a crime. Judge Lawrence Silberman, in his opinion for the Circuit Court of Appeals for the District of Columbia, invalidating independent counsels as unconstitutional, cited Mr. Walsh's misstatement of prosecutorial discretion. Judge Silberman emphasized that more is at stake here than the dry concept of separation of powers. In his words, individual rights are at stake. He noted that there are, in his words, unique incentives to seek an indictment. Our concern, he said, echoing Attorney General Jackson, is based on the self-evident proposition that the whole raison d'etre of the independent counsel is not to administer the criminal law across a wide population, but rather to focus on one individual or group of individuals targeted at the inception of the office. As with other independent counsels, Mr. Walsh has not only ignored normal Justice Department policies, he has also ignored the national security and diplomatic considerations that would normally help guide a federal prosecution. There is a good reason that the Constitution assigns the authority to prosecute and to make foreign policy to only one branch, the executive. Mr. Walsh has subpoenaed 1 million pages of documents relating to foreign affairs, some of which have since mysteriously appeared in the press. His deputy, Guy Struve, told the Court of Appeals that if there was a conflict between the Secretary of State and the independent counsel on a prosecution, the independent counsel would follow his own desires. Diplomatic considerations were entirely ignored by independent counsel Whitney North Seymour. Mr. Seymour wanted to get testimony about Michael Deaver's lobbying from Alan Gottlieb, Canada's ambassador to the United States. Mr. Seymour, who actually had stationery made up with the eagle on the Justice Department seal facing in the opposite direction, twice tried to subpoena Alan Gottlieb. After Canadian complaints, the State Department complained to the judge that this was an obvious violation of diplomatic immunity. The courts agreed. Ambassador Gottlieb never testified. The headlines recently have dealt in some detail with the investigation by independent counsel James McKay relating to Attorney General Edwin Meese's role in a proposed pipeline from Iraq to the Jordanian port city of Aqaba. This is just the latest in a series of accusations against the Attorney General, not one of which has been proved. As a result of James McKay's investigation in this case, correspondence referring to a secret agreement between Israel and its Arab neighbors, Jordan and Iraq, became public. Israel agreed not to bomb the proposed pipeline. After all, it's not in the business these days of bombing Jordan. And the publicity embarrassed the Arab heads of state as well as the Israeli Labor Party. And to what end? The legal claim against Mr. Meese is really quite bizarre. One, the Foreign Corrupt Practices Act only applies to bribes paid by Americans. Here, the alleged bribe would have been paid by a Swiss businessman. Two, the bribe was never paid. For that matter, the pipeline was never built. Three, it is not a crime for the Attorney General to fail to bring an indictment in any case. This is the heart of prosecutorial discretion. Finally, Alexia Morrison's investigation of former Justice Department official Theodore Olson has reached new heights of prosecutorial indiscretion. Mr. Olson has been investigated now for 2 years on charges that he lied to Congress in 1983 in testimony relating to the Environmental Protection Agency. This is a classic case of executive privilege as against a Congress that wants to know. Ms. Morrison tried to coerce Mr. Olson into signing away his right to the protection of the statute of limitations, which runs out next month. Just before Christmas, in fact, she asked a federal judge to jail Mr. Olson unless he waived these rights. The judge refused. More recently, Ms. Morrison has threatened to bring what she calls a protective indictment against Mr. Olson to keep the statute of limitations from running out before she collects enough evidence to warrant a case. The American legal system has its own genius for correcting abuses. Judge Silberman's ruling, if it is upheld by the Supreme Court, will teach Congress a harsh lesson about the dangers of usurping executive branch powers. The conviction of Michael Deaver and the investigation of Theodore Olson will be quashed because the independent counsels in these cases operated entirely under their Ethics in Government Act authority as independent counsels. Lawrence Walsh and James McKay did accept parallel appointments inside the Justice Department after legal challenges to independent counsels were filed. But, and this is a big but, both counsels had impaneled grand juries and subpoenaed documents and called witnesses before they took the parallel appointment. I believe that any period spent as an illegal prosecutor, as no more than a vigilante in the eyes of the law, taints these investigations beyond repair. The result could therefore be that Ollie North, John Poindexter, Lynn Knopfsinger, and Edwin Meese will go free, and double jeopardy and statutes of limitations will prevent any later investigations or convictions. Congress throughout thought that it could get persecutions of executive branch officials. Instead, if the Supreme Court upholds Judge Silberman's opinion, Congress will get a lesson in why the protection of individual rights requires that only prosecutors supervised by the executive branch can prosecute citizens, including citizens guilty only of working inside the executive branch. Thank you.
Thank you, Gordon. I want to commend the first two speakers, both of them being lawyers, with the exception of a slight slip into a reference to mens rea on Gordon Krovitz's part. They confined themselves to the policy issues and left for our cleanup hitters a discussion of the legal issues. That discussion will be commenced, Tom, by you, and followed by Phil Hyman. Oh, all right. You're going to do double duty, Fred. You didn't know that. And then we'll, as I say, we'll have a free-for-all where everybody can enter in. But to state the administration position, Tom, I'll introduce you.
Thank you very much. Gordon took a lot of my quotes. That's right. Well, there's not a great deal of difficulty in finding out who should become the victor. John Bolton, who was originally supposed to be here tonight, sends his regrets. John spent 7 years in New Haven, and I'm sure would have been very pleased to have been here surrounded by so many Harvard types. Me, I'm from Virginia. I'm just pleased to be here. I want to tell you something that you probably are unaware of given the conversations we've heard or the discussion we've heard to date, and that is the Department of Justice supports an independent counsel statute. Maybe I should repeat that. The Department of Justice supports an independent counsel statute. We've stated that on the record in the House and in the Senate. Indeed, the Department of Justice has expressed reservations about this particular statute since 1974. But our support for what is now lies before the Supreme Court is based on two reservations. The first is that the statute has to be constitutional. And the second is that it treats those individuals who are subject to investigation pursuant to that statute in fair and equitable way. Gordon alluded, as a matter of fact, to the comments by Judge Walsh to the effect that in his judgment it was sufficient to establish only that probable cause exists before going forward with indictment and trial. The Justice Department standard is reasonable doubt, in effect, because the request is that we expect our prosecutors to have a pretty good idea that they can achieve a conviction by an unbiased jury before going forward. And as most of you know, beyond a reasonable doubt is a considerably higher standard, much more difficult to achieve than probable cause. And yet Judge Walsh feels that probable cause is sufficient to go forward with an indictment. Now, our constitutional reservations are really threefold. I noticed that we all had the same little pocket Constitution with us, and the two principal concerns that we have reside in Article 2 and Article 3 of the Constitution. Article 2, very simply, is divided for purposes of this discussion into two parts. First, Article 2, Section 2 requires that the President must nominate all officers of the United States. And the second portion of that section indicates that Congress has the power by appointment to invest such inferior officers as they deem proper in the President alone, in the courts of law, or in the heads of departments. And that has been used for those who propose that the statute is constitutional to indicate that Congress can lawfully designate to a court of law the power to appoint a criminal investigator. We take the position that the investigator can't have it both ways. Either the investigator, either the independent counsel is an inferior officer, in which case that counsel is subordinate to someone, or he is a principal officer, in which case the President has to nominate him and the Senate has to confirm him. And we heard Fred speak briefly about the necessity of this, the bipartisan support for this statute. But let me quote, if I may, from the Supreme Court's holding in Chadha, INS v. Chadha, which was the one-house veto case in 1983. The choices we discern as having been made at the Constitutional Convention impose burdens on government processes that are often clumsy, inefficient, even unworkable. There is no support in the Constitution for the proposition that delays often encountered in complying with explicit constitutional standards may be avoided either by Congress or by the President. Our sense is that this type of statute, as it's currently constructed, and I should add that the new statute that was just enacted last December is far worse, is simply constitutionally defective. The independent counsel has to be subordinate to someone, and under the construction of this statute, he is subordinate, if at all, to a body of judges. That is insufficient to pass constitutional muster in our judgment. Secondly, a responsibility to the President, which is contained in Article 2, Section 3, is he should take care that the laws be faithfully executed. That means he has to prosecute crimes in our judgment. There is really no fundamental precedent for the concept of having a court appoint a criminal prosecutor with an unlimited budget, with an open-ended tenure, and no means by which to, as a practical matter, be removed. Now, Fred made the point that removal can be had by the Attorney General for good cause, and that's true. The problem is that if the Attorney General were to make the decision to remove an independent counsel for good cause, he'd have to have that decision reviewed by the very body that appointed the independent counsel in the first place, the same panel. And we've spoken a little bit earlier about Judge Walsh's view of what is necessary to proceed with the prosecution. Let's assume, for the sake of argument, that Judge Walsh, who has accepted a parallel appointment from the Attorney General and is therefore at least lawfully subject to the regulation of the Department of Justice, was informed that he was to go forward only upon Justice Department standards. Let's assume, for the sake of argument, that he refused to go forward along adopting the Justice Department standards, but instead chose to adopt the one he's articulated publicly. Would that constitute cause? And do you think that a reviewing panel would be in agreement? Do you think a reviewing panel would remove him for failure to follow those kinds of regulations? I should also note that the statute itself requires that the prosecutor, the independent counsel, follow the regulations having to do with prosecution in the Department of Justice. The problem is, how do you enforce it? We have been very fortunate to date that some of our independent counsels have been pretty good about how they proceed. They've done so professionally and efficiently. But the type of statute we're talking about is one which invites abuse. It invites a prosecutor to wish or to attempt to make a reputation based principally on, dare I say it, blind ambition. We're asking for that with this kind of statute. And we also believe that you simply cannot regulate, or you simply cannot designate an officer of the court effectively to be a criminal prosecutor. It just simply cannot be done consistent with the requirements of Article 2. Lastly, I should point out about Article 3, which in our judgment is also at issue here. The court which makes the appointment is a court which is empowered under Article 3 to address only those cases and controversies which are consistent with its responsibilities. It is not empowered, in our judgment, to appoint criminal investigators. You can go forward with continuing investigations. The case of Ted Olson has been raised here, and we've spoken earlier about Mr. Channel, who was found guilty of an odd charge. In fact, he pleaded guilty to that charge. What was not mentioned is that Mr. Channel's lawyer is Alexa Morrison, who is the independent counsel contesting the constitutionality of this statute. Now, she represented, in this instance, Mr. Channel, who was being investigated by one independent counsel, while she was carrying forward an argument on the other side with respect to her responsibilities in the Olson case. I think you have to ask yourselves whether this is appropriate or proper, but she did it. And you have to also question if, since Mr. Channel pleaded guilty during the period of time before Judge Walsh assumed a second and accepted a parallel appointment, would she have been willing to challenge the constitution of the statute on behalf of her client? There are fundamental problems that we're dealing with when we're talking about this statute. It may be convenient, it may be a good idea, but we take the position that it's fundamentally and irrevocably constitutionally defective. We are prepared to work with Congress. We have said that, as I indicated at the outset, and we're prepared to do so as long as it takes to come forward with a constitutionally supportable statute. So this is simply not it. And its successor, which will ultimately be challenged even if this one is upheld, is also similarly defective. There are ways to do it. There are ways to maintain confidence in government, confidence that people at high levels will be treated with the same degree of scrutiny as everyone else. It can be done. This statute, however, doesn't do it. Thank you.
Phil Hyman, you have the opportunity to finish up our panel discussion or defer to Fred Wertheimer, but I think you're moving towards the podium, so you're going to take up the cudgel. Phil Hyman.
Thank you, Dick. Tom said the statute is convenient. The statute wasn't passed to be convenient. It was passed because deep-seated cynicism is a terribly eroding force in any nation, in any democracy. It can kill a country. And cynicism will result from either of two things. Cynicism about the law. Either a belief that the highest officials are not subject to the law, or and think about it, this is even worse, a belief that they say they're subject to the law, but decide for themselves when it will be applied to them. Either of those leaves a large measure of the public thinking that the law applies to them, but not to their leaders. And that is a very dangerous situation for democracy. It's that, incidentally, that fear has led 41 of our 50 states to create a chief prosecutor, an attorney general, who is in no way subject to the executive power of the governor, although each of those 50 states has the same belief in separation of powers that the federal government has. The fear of that cynicism led Congress and two presidents, Congress twice and two presidents after some experience, a Democrat and a Republican, to pass a law designed to keep as much of our federal practice, which has for some time had prosecutors subject to the president, as possible, but still deal with the problem of cynicism. The law required the Attorney General to decide for himself when the situation was such that one of a named list of people had to have a full-scale investigation. The Attorney General was to decide that. The special prosecutor, the independent counsel appointed, was to obey Justice Department regulations as far as, quote, possible, unquote. And I have no quarrel with Gordon or Tom if they say some special prosecutor is not obeying the regulations, is not behaving consistently with established policy, and that's wrong. I believe in almost every case that is wrong. I think they should obey, and that's what Congress said, and that's what the statute said. And the statute said that the Attorney General could fire an independent counsel for good cause, which I take it includes failing to obey standard department policies when it's possible to obey it. The tradition has been that trusted old fire horse prosecutors, fire horse makes it sound like they want to go to the fire, but not that. People who have long experience as prosecutors have been appointed by the court that appoints them. They're not private lawyers trying for the first time to find out what a prosecution is about. The result of this way of dealing with cynicism is, when you think about it, to empower an administration with the power of having people obey the laws because they think everyone has to. And without that power, administrations are very weak. If you were president, you would want this law. Well, there are moral and constitutional challenges set forth, or ethical or fairness. Gordon says, there's much too much incentive for an independent counsel to prosecute. After all, these people have a blank check. Some of them establish very large staffs very quickly. And then wouldn't they be, I suppose, embarrassed or worried that they would disappoint their staffs if they didn't prosecute? The fact of the matter is the prosecutors haven't, in general, behaved that way. The independent counsel, both appointed by presidents or attorney general and appointed as part of the statute, have acted responsibly. It's not so surprising. It isn't great fun as a prosecutor to bring a case with great notoriety and have it end in acquittal. You feel a little humiliated. And there's a tradition that the prosecutors live through, a tradition of not bringing cases unless they believe it's justified and that a conviction will result beyond a reasonable doubt by 12 jurors. Hamilton Jordan was not prosecuted. Ed Meese was not prosecuted. Donovan was not prosecuted. Jimmy Carter, this is an appointment by the Justice Department, was not prosecuted. The prosecutors have not been running wild. But there's a more basic answer to Gordon than that. There are big problems and there are medium-sized or small problems. And the Special Prosecutor Bill deals, the Independent Counsel Bill, deals in the realm of fairness with a very big problem. I'm perhaps the only person around, anywhere, not just in this room, who lived through the period when there were not independent counsel as head of the criminal division, and then the period when there were independent counsel or special prosecutors, and saw both. It is almost impossible for a prosecutor in the Department of Justice to exercise the discretion a prosecutor has to decide whether something seriously wrong was done and whether it can be proved. And that's what prosecutorial discretion is all about. To do that fairly when he is or she is torn between two risks. On the one side, the call to some measure of loyalty and sympathy for colleagues and for people who have perhaps been behaving, as Gordon pointed out with Ollie North, on behalf of administration policy. And on the other hand, the prosecutor is pulled towards acting with a strictness and a severity that says, I am above bias. I cannot be tempted. I am not biased. That is a big problem, trying to do justice in the way of prosecutorial decisions when you are pulled both by friendship and by the suspicion of friendship at the same time. That's inherent in the situation facing a Department of Justice lawyer. It's a bigger problem by far than the problem of worrying about what you're going to do, how you're going to explain to people that you had a large staff for a substantial period of time and did not bring a prosecution. That's the small problem that the independent counsel faces. It makes a little difference, by the way, if you were living during the period of the Carter administration, you would have preferred having an independent counsel investigate you, because we bent over backwards to bring to trial people where the cases were at least somewhat on the close and marginal side. We charged Bert Lance and got an acquittal. We charged another friend of the president in North Carolina and had an acquittal. You would have wanted an independent counsel. It may be that with this administration, you'd prefer not having an independent counsel. I don't know. But I know that the problem faced by a Department of Justice attorney is more severe than the problem of having an independent counsel who has invested a great deal of government resources before he has to decide whether to prosecute or not. Let me switch to Tom's area, the question of law. There are really three arguments here, and I'll try to be fast and I'll try to be clear, and it's a little hard to do both at once. The first argument is that Article 2, Section 2 of the Constitution says that the President shall have power with the advice and consent of the Senate, shall nominate with the advice and consent of the Senate ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. If it sounds to you like that language doesn't throw much light on the question of the independent counsel, you've understood it clearly and well. It does not. There's no way that that language can help you much, and there is no legislative history of that language that suggests anything more than a very wide discretion in the President and the Congress to decide which are the inferior officers that courts can be told to appoint and heads of departments, and which are the others that only the president can appoint. Justice Story, a very great judge in about 1830, read that language and said just that. He said, boy, it must mean that it's up to the Congress and the president to decide. People who were there when the language was written were in the first Congress. 6 of them were on the Judiciary Committee in the Senate that reported out the bill that was the first Judiciary Act. That bill declared that the Attorney General and prosecutors should be appointed by the Supreme Court and the lower courts. Then, on the floor of the Senate, without any meaningful explanation, and with hardly any explanation at all, they gave that power to the president. But apparently, members of the Constitutional Convention believed that it was just fine to give the power to appoint prosecutors to judges. But, Tom and Gordon say, it has to be an inferior officer. An inferior surely means inferior to someone else. You must be working for someone if you're to be an inferior officer, because only inferior officers can be appointed by courts. That, frankly, is an anachronism. Well, it's also a misuse of the language as it is used today. I had an inferior meal at lunch today, and my meal did not report to anyone else, except to me. Inferior means, and particularly meant in the status-conscious days of the late 18th century, of lower status. And that's what it means in that clause. Alexander Hamilton suggested that perhaps there was one meaning for superior that had to be taken seriously, that the president should have to appoint people who report directly to him and advise him. Makes some sense. People shouldn't have their advisors appointed by someone else. But be that as it may, it doesn't affect the fact that there is nothing in the history or language of the Appointments Clause to suggest that the independent counsel cannot be appointed by a court. And indeed, there's a Supreme Court case, the Siebold case in the mid-19th century, where a court is asked to appoint an election commissioner who is, and the court sustains that without much difficulty. There's a second argument. The opponents of the independent counsel law say, well, forget about that. Article 2, Section 3 of the Constitution says the president shall receive ambassadors and other public ministers. Forget about that. He shall take care that the laws be faithfully executed. Surely that means that the president must be the chief prosecutor, the argument goes. He shall take care that the laws be faithfully executed. Well, let me say just a word about the structure of separation of powers arguments in the Supreme Court. They take 2 forms. One form is when Congress, or perhaps the courts, take unto themselves powers that would otherwise belong to the executive. The Supreme Court is very cautious, very leery, very likely to strike it down, saying if Congress starts taking executive powers, all the powers will end up in Congress. There's another type of separation of power question, and that is where some powers are removed from the president, but not given to Congress. Given independence, like an independent agency, the Federal Trade Commission, the Federal Communications Commission, the Federal Power Commission. I could go on for about 12 more commissions. Those questions have never much troubled the Supreme Court, where it's not another of the 3 great branches aggrandizing itself, but simply setting up something independent of the 3 for good reason. I mentioned that in 41 states, the Attorney General is independent of the Chief Executive, the Governor, and in each of those states, all the local prosecutors are independent of the Attorney General and of the Governor. We have a tradition of prosecutors that are independent of chief executives. Well, what about this language, execute the law? The president shall see that the law is executed. It doesn't mean prosecute. There's no history to suggest that it means prosecute. It means the President shall see that the laws are carried out. If Congress says a dam shall be built in Connecticut, the President shall see that a dam is built in Connecticut. If the law says 3 frigates will be built in Virginia, the President is to see that they are built in Virginia. Britain never had prosecutors subject to executive power. It used private prosecutors until well into the 19th century, when it got a public prosecutor with very limited powers. When the Judiciary Committee and the Senate directed that prosecutors be appointed by the President in 1790 about, the President appointed practicing lawyers who were paid on a fee-for-service basis. They were not employees. And of course, as I mentioned, independent agencies were left free to execute some laws. The President didn't have to execute them all. And in the case of United States versus Nixon, involving the Watergate prosecution, the Supreme Court sustained the right and power of President Nixon to give away by regulation the authority to carry on prosecutions to a special prosecutor. Well, let me mention the last and then leave you. Well, what about firing? Doesn't the last argument go, doesn't the President have to have the right to fire any prosecutor? The answer to that takes us back to where we began. There's an established exception in the Supreme Court cases. The famous cases are one Humphrey, another called Weiner, which says that Congress can limit the power of the President to fire except for good cause, and that's the rule for independent counsel, where there's a manifest necessity for independence. There is a manifest necessity for independence when the question is whether the highest officials in the United States shall decide for themselves whether they are subject to prosecution. Gordon talked admiringly of Judge Silberman's opinion, where Judge Silberman said, what could be more of an executive functionary, it's not his term if I say apparatchik, than a prosecutor? Not Silberman's term, my term. He's wrong. Prosecutors have for some time thought of themselves as quasi-judicial, bound by obligations found in the codes of professional responsibility, found in thousands of pages of Department of Justice manuals, as officers of the court, limited by what courts say, and is in their very function of prosecutorial discretion, bound to try to perceive what the public at large thinks is the worst behavior, and even then prosecute it only if the evidence is strong. That is the very definition of a person who should not be subject to the control and whim of the President of the United States. And that's the way it's been for many years.
Thank you, Phil, and thank you all of our panelists. I'm bound to ask the question that I'm sure is on the mind of all of you here present this evening to begin our discussion, and that is whether Phil Hyman's inferior lunch included the ham sandwich that's in jeopardy of indictment under Gordon Krovitz's theory of the special prosecutor law. Gentlemen, I think what we are going to offer you now is the opportunity, as you see fit, to comment on the presentations made by the other members of the panel, or as you wish to raise other points that may have escaped you in your first presentation. And you can address them to each other as you see fit without the interference of the moderator. Fred Wertheimer.
I just wanted to point out that, as I said in my presentation, Phil would clearly explain my legal thinking on why this law is constitutional, and he has done that. That is my thinking on this. Thank you.
The lawyer brought his own lawyer. Phil?
Well, I want to pick on Gordon.
This is your big chance.
All right, a lot of the things you said, look, you talked about all the wrongdoings, and Tom talked a little bit about the wrongdoings of these independent counsel. Well, if they do wrong, I would say to you, fire them. They are obligated not to do wrong. They're obligated to abide by Department of Justice regulations. But that's not my picking on point. A lot of the things you said just are not right as a matter of law. Running you backwards, you said, well, that the independent counsels are going to suffer a heavy blow because there won't be any prosecutions as a result of double jeopardy. Well, double jeopardy doesn't attach to any conviction that is reversed on appeal, and it doesn't attach to any case that never got before a jury. I don't think any of these cases are in any risk of being not brought because of double jeopardy.
You don't think the convicted Michael Deaver has a claim of double jeopardy?
No. He'll get if he wins a reversal, which I don't think he'll win, he will be tried again. He can be investigated again. There's no right under double jeopardy not to be indicted twice.
Can I interrupt on that?
Sure.
Point one. Deaver was convicted of a perjury count. Mm-hmm. An independent counsel was assigned for the purpose of investigating him for violations of the Ethics Act. They found no violations of the Ethics Act. They indicted him for a perjury count. That perjury count before a grand jury would be thrown out by a reversal of this case, or rather sustaining the current holding, and they'd have to reinvestigate him. But the perjury charge would be void, would be gone.
You mean the holding would be that it was all right to lie before a grand jury if the prosecutor was not properly appointed?
If the prosecutor is invalid, then the grand jury is invalid.
I doubt it. You said that Attorney General Meese, Gordon, you said it's ridiculous to think he could have violated the Foreign Corrupt Practices Act because it only applies to Americans, and this was action taken by a Swiss named Rappaport. Is that his name? However, Rappaport was working with an American named Wallach, who is a very close friend of the Attorney General and who was in contact with the Attorney General. I don't have any particular belief that the Attorney General's conduct was or was not a violation of the Foreign Corrupt Practices Act, but there's no problem of finding him. The problem would not be that that there's no American with which he conspired. He conspired with, if anybody, with Wallach, his good friend and lawyer.
Well, so you want to bring him on a conspiracy charge, or do you want to bring him on the Foreign Corrupt Practices Act?
The
Foreign Corrupt Practices Act applies to any American or an agent who's an American. You'd have to make the case that a lawyer loses any immunity as a lawyer in this case. But the point is that it's really quite absurd to think that you can bring an action against an Attorney General for failure to bring an action. I mean, if that is to become the law, then any time a lawyer thinks that a case should have been brought, he'll bring an action against the U.S. government for failure to bring an action. And the litigation explosion that we now have will be peanuts. So, I mean, there are several grounds on which it's a ridiculous claim.
Is that the issue, though? Failure to bring an action, or is the issue that?
No, well, if Edwin Meese has committed a crime, it is failure to bring an action. There's no, even in the leaked documents, there's no evidence that he did anything to help pay a bribe that was never paid, for a pipeline that was never paid. I mean, this is yet another example of the kinds of attacks on the Attorney General that he's lived through for 7 years now, and I wonder if we aren't going to get to a point where even those of us who have our own suspicions about Edwin Meese are going to say, gee whiz, if all these resources have been used for 7 years to bring down this man and they can't get anything, maybe he's clean as a whistle. And I think, if I can pick on Phil Hyman for a moment, you gave a nice...
Say Hyman.
I'm sorry.
That's okay.
I am sorry. With a name like Krovitz, that's not the kind of mistake I
Right.
like to make. You gave a nice speech about deep-seated cynicism, and I couldn't agree with you more. Cynicism is a terrible problem. You said that there are two kinds of cynicism. One is that government officials are above the law. I couldn't agree with you more. Congress is not subject to special prosecutors. Congress exempted itself from the Equal Pay Act, the Occupational Safety and Health Act. Congressmen, when they are investigated by Justice Department prosecutors, are able to use their campaign funds to pay their lawyers. There was an article, I don't know if you saw it, in the Legal Times of Washington, D.C., urging the lawyers that if they have a choice between taking a congressman as a client and taking an executive branch officer as a client, take the congressman. They can pay for it out of their campaign funds. The second thing you said that leads to cynicism is when you have officials who say that they're under the law, but where the people don't really believe that they are. What we're talking about here, I think, is accountability. And a lot of what we've heard tonight has been about legal accountability. I want to ask, where's the political accountability? We've had an experience with the president who resigned, who had a special prosecutor, where there is no doubt or very little doubt in the public's mind that some of the things that he did were just plain wrong. Richard Nixon was not brought down by a Lawrence Walsh or a Jim McKay or an Alexia Morrison. He was not brought down by an unconstitutional prosecutor. He was brought down by a special prosecutor inside the Justice Department. And I know that Judge Silberman's opinion is not the favored opinion of at least two members of this panel, but I do want to read just a couple of sentences from his opinion that had to do with this point about accountability, whether it's political or legal. He said, "The Watergate crisis is, of course, the statute's genesis, and it is in order to spare the country a repetition of that long national nightmare that the statute has been enacted. That justification assumes, wrongly we think," he says, writing for the court, "that prosecuting presidents can somehow be made relatively painless. We do not see how such an eventuality can, no matter what structural techniques are employed, be other than a national nightmare." I think that's quite clearly correct. There is no easy way to bring down an executive branch officer, a president or another high-ranking executive branch officer, and certainly not by special prosecutors who by their actions bring into doubt the credibility of their cases and indeed point to hypocrisies in the law that I think bring about a general disdain for all of the laws in question here. If we're going to get rid of executive branch officials, let's do it through politically accountable prosecutions. That means that if people decide that Edwin Meese should have been indicted and convicted and run out of town on a rail years ago, they will have an opportunity this November to tell his party that he shouldn't have been around. That's accountability. I myself don't think that's going to happen. That suggests to me that the political views of people are that some of these prosecutions are frivolous, that maybe there is a lynch mob atmosphere. And the question that I think proponents of independent counsels have to answer is this: what does that do to respect for the rule of law, where we have 7 years of prosecutors on various high horses who aren't able to bring down some of the men that they are trying to?
Could I make a couple of comments? First of all, on the point about Congress exempting itself from statutes, it's absolutely correct. It's wrong. They do it all the time. In some cases, they're not successful. In other cases, they may have some basis. They have not been covered by the revolving door legislation that Mr. Knopfsinger was prosecuted under. They should be covered. There is legislation pending in Congress about to go to the Senate floor, which is unanimously reported out by the Senate Judiciary Committee, which will cover Congress and their staffs, as well as the executive branch. So that's a legitimate problem. How do you hold Congress accountable to standards that that we believe should apply to others. That is not a justification for anyone going out and violating laws that exist and correctly exist with respect to the executive branch. The second, it has been used as a justification. It just doesn't work. Second point I want to make is that this is not a question of bringing down executive branch officials. And I must say, the discussions one hears about prosecutorial abuses and the ability for prosecutors to go beyond their normal controls seems to take on a different tone with respect to the administration language when they're talking about executive branch officials than it does when they're talking about law enforcement in general. Now, part of what this administration ran on was a notion of a tough-minded, hard-headed approach to law enforcement. And one would hope and assume that their views about law enforcement incorporated a notion of fairness and even-handedness. And it is when one starts to look at the issues of applying the notion of law enforcement to those who hold power in this administration that the debate seems to switch to unaccountable or prosecutors and prosecutions, the same kinds of concerns that Gordon raised about the independent counsels that have been appointed over the years. Those very same kinds of questions and issues can apply to any prosecutor and to any Justice Department or to any local situation, Attorney General, local prosecutor. So I think that it's important to keep in mind at least the basics in this discussion. And I think the basics involve the following. If you expect people to accept the notion of our legal system and a system of law enforcement that applies to everyone, then you have to have a credible way of dealing with those who hold the power, the life and death power over everyone else. And the fight here and the issue here really does come down to one central question. And Tom, in effect, alluded to it when he talked about the administration being in favor of some forms of independent counsel. It comes down to whether or not you have a system for determining whether or not to prosecute top government officials that is controlled and directed by the President of the United States to the Attorney General, or that is independent from him. That control and direction is the key test. And I would also add one final point. I don't think Ed Meese would be Attorney General of the United States today without the independent counsel law. I don't think there is a prayer that he ever would have been confirmed, given the situation that existed, given what was on the table, had he not gone through the process of having an independent counsel look at his situation and reach a conclusion brought back to Congress that there was no basis for prosecuting his activities. These independent counsel laws can, and I submit have worked to the benefit of those who have been subjected to them as individuals, as well as to the benefit of the country.
We've given our panel the opportunity to warm up on one another. I think we are now going to move to the audience to let you question our panelists. If you will use one of the microphones that's strategically placed around the forum this evening, and please ask a question and not give a speech. If you want to give a speech, we'll let you come to your own forum program in due course. I'd like to ask one question, and I think it may, in truth, be one on a great many people's minds. How many times has this statute or its predecessor been utilized to actually appoint a special prosecutor?
About 8.
8 occasions?
Oh, not to actually appoint. It's been invoked 8 times. How many times is... No, special...
There were 2 times in the Carter administration in the first 2 years of the statute. I think that there have been 6 in the Reagan administration.
That's probably right.
Okay. And in each case, that appointment is made at the request of the Attorney General then in office.
That's correct.
Ultimately, yes, although a couple of the instances, including the one before the Supreme Court, were initiated by Congress.
Okay. Yes, your question.
You went on for quite a while about how it's important for these prosecutors to be independent and the history of them being independent. Yet the problem obviously is in a situation that, for example, the Attorney General is under prosecution or investigation, what to do about a prosecutor who is not following the norms. You seem to put a lot of faith in the prosecution to follow the rule of law and so forth. Now, your response to whether if those rules are not followed is to have the special prosecutor fired. Well, if the Attorney General is under investigation and he fires a special prosecutor for not following the rule of law or the rules of prosecution, then you're back to square one. It may as well have been one of his own subordinates doing the prosecution. So I just wanted you to clarify that apparent contradiction.
Well, you're not back to square one because the court would then appoint another prosecutor to replace the one that was dismissed. And the Attorney General wouldn't make that appointment. The Attorney General would take a considerable amount of flack unless the good cause were very well established. But if there was clear good cause, Attorney Generals have to be prepared to take that flack. And it would just result, and the Attorney General could be the first to say, there will be another special prosecutor appointed, but I have to raise the question of unfairness here. Incidentally, if it was the Attorney General himself who was under investigation, he should disqualify himself from handling the question at all. He should turn it over to someone else in the Justice Department who would then fire the prosecutor for good cause.
Well, he may disqualify himself, yet the problem remains of whether someone in the executive branch will make that decision. Obviously, among the panelists, there's ample disagreement as to what would constitute a crossing those boundaries of prosecutorial discretion.
It would have to be a relatively clear wrongdoing by the prosecutor, something that I don't think any of these prosecutors have done, though Tom took me a little back on
Judge Walsh.
On Alexia Morrison. What Judge Walsh said, by the way, seems to me to be wrong. I don't know whether he's been willing to retract it or not. His statement that he would prosecute if there was probable cause is the standard set forth by the ABA, is the standard for prosecutors. The federal government has a higher standard for prosecutors, and I agree with Gordon and Tom that the Department of Justice regular standard ought to be applied by the independent counsel. But I think maybe you're making too much of it. I think perhaps he misspoke himself, as other officials do sometimes.
Is it legitimate at these forums to answer someone else's question?
Surely, absolutely, anytime.
I think that was an awfully good question, because it seems to me that we have several examples of actions by prosecutors that would, under normal conditions, be more than good cause. It would be extraordinarily good cause to remove, and yet Tom's Justice Department hasn't done it. I mean, let's take a couple of
Shows
practical...
the system works.
I'll get to that. The practical effect and the problem that civil liberties, people interested in civil liberties ought to be worried about are the cases of some of these individuals. Carl Channell and Richard Miller have now pleaded guilty to a crime that, one, the Internal Revenue Service to the tax division of the Justice Department have said was not a crime. They faced jail sentences. One of them was represented by an independent counsel in another case, and the last thing that she, Alexia Morrison, wanted to do was to bring a constitutional challenge to independent counsels. We have Lawrence Walsh making a statement that has all of Washington abuzz, wondering how on earth someone could say such a thing. We have Ted Olson, almost dragged into jail 2 days before Christmas in order to sign away his rights to a statute of limitations protection. And in all of this, people like me keep calling the Justice Department up and saying, hey, what are you going to do about this? And the answer is, the most recent answer from the Deputy Attorney General to a question of that kind that I posed to him was, I have a very simple answer, I don't know. And the reason they don't know is that they don't want to take the political heat for replacing a special prosecutor, no matter how outrageous his or her behavior. Now the question is, do we want the Justice Department in that position where it takes political heat in that direction, or would we prefer to have an executive branch that takes the political heat of losing at the next election if it doesn't properly investigate its own, which is how the system worked until 1978 without tearing the country apart, it seems to me. I mean, political accountability in the end is what we ought to be talking about, not legal formalities, but a political accountability. And it seems to me that an executive branch that has to answer to politics is going to do a better job of investigating itself than the current situation where people have no idea whether convictions are valid, whether trials that go on for years and into next administrations are valid prosecutions, and that raise all of these questions of a tainted prosecutor, which must be among the greatest violations to civil rights imaginable.
Just one point. This administration doesn't have to answer to political accountability. This is a lame duck administration. Now you can equate this administration with a possible next Republican administration, but this administration, political accountability does not go to the public again.
And there's no political accountability for an investigation that never got started, Gordon. You know, you have, I believe honestly, one has a certain tendency to say, well, there's a big investigation, it's of a high-level official, and the administration says no, the way they did in England and Northern Ireland. We won't prosecute. For that, there would be a huge backlash. But if it's at an early stage of an investigation, and the message is, why don't you just forget about that to the line prosecutors in the Justice Department, there will never be a backlash. The matter will be buried and forgotten.
Well, it depends on how far you think our prosecutorial politics in Washington has taken us. I doubt that there's anything, no matter how innocent, that an executive branch officer has done in the past 7 years that hasn't made its way into the hands of a congressional staffer and then on to the next step, whether it's a reporter or an independent counsel.
Do we have any other questions to pose to our panel this evening? Yes, sir. You'll move to the microphone, please.
I'd like to hear from Congressman Gordon on the conflict of interest point raised by. I haven't heard anything from you guys as to how you answer this conflict of interest argument.
Well, if you're talking about what's alleged to be the inherent conflict of interest in the statute, is that what you're referring to?
Well,
trying
to prosecute your own.
Well, I think, as I said at the outset, I think that we are sympathetic with the point of view that was articulated first by Fred, that we need to have accountability at high levels of government. We have no problem with that. We've stated that time and time again. The problem you have, it seems to me, is a question of how do you go about doing it? What kind of a structure do you establish in order to make sure that people are treated fairly and that the constitutional requirements are met? And our sense is that you could set up, there are any number of different mechanisms, but one, for example, could be one in which the president at the beginning of an administration or every alternate Congress could nominate a series of independent counsels who could be confirmed by the Senate, and those people could sit in the bullpen, if you will, until needed. We've had a total of 8 over the course of the life of this statute, 2 in the first 2 years, 6 in the past 8. At this rate the Carter administration was establishing independent counsels, we'd have had 8 over this course of the same amount of time in the Reagan administration. So we have to expect, as a matter of fact, that the new statute was far broader with respect to the ease with which an independent counsel can be appointed We're going to see more of them in the future if the statute is upheld, and we're going to see them for a lot less justified reasons.
Can I just disagree with the Justice Department here for a moment?
Again?
Well, I really don't think that the Justice Department has thought this out very well. Independent counsels can be very handy when they find executive branch employees to be not guilty. But the existence of independent counsels, the existence of an apparatus outside the normal Justice Department procedure seems to me to be a guarantee of abuses of one kind or another. And for political accountability purposes, the system that we had before 1978 seems to me to be far superior, where where the party in control of the executive branch will be punished if there is an idea abroad that it hasn't enforced the law against its own. That seems to be a much cleaner system that doesn't raise all these civil liberties problems.
Could I ask the moderator a question? The moderator was head of the criminal division. How independent did you find the 95 U.S. attorneys to be and their 2,500 subordinates, Mr. Thornburg? Did you feel that they were
About as independent as you did when you were the head of the
I couldn't
criminal
control.
division.
I found them absolutely independent.
They
This
are
picture,
independent. Yeah, I was a
Yeah.
U.S. attorney once too, so I
You were one of the
treasured
hardest
that
to control.
independence.
That's right. Now this is. I mean, it's not
Now,
like. Yeah.
The point is well taken. I think there is a degree of independence. I think, however, when you hark back to the case that was probably the most challenging for any U.S. attorney in the history of the Department of Justice was when George Bell was handling the prosecution, investigation, and ultimate prosecution of the Vice President of the United States, Spiro Agnew, that he was not off on an independent frolic of his own, that there was a very close coordination with the Department up to the Attorney General, Elliot Richardson, at the time, so that while there certainly is a degree of independence, United States attorneys were fond of informing the Attorney General that both the U.S. Attorney and the Attorney General were presidential appointees and that therefore they held some kind of equal status. In a particular case of the sensitivity that's within the ambit of this independent counsel statute, I think that there is a different kind of setting.
And would you have felt appropriate in that case? Inappropriate in that case, Dick, for it to go to the president to decide rather than the attorney general?
No, I think
So it would be independent of the president, although the
Yeah.
president is the chief executive. Okay, I rest my case.
I have a question over here.
Oh, good. Okay, excuse me. In the balcony.
That's okay. This question is sort of directed to Mr. Boyd and Mr. Krovitz. I share your concern about civil liberties, but I find it more than a little ironic that you seem very concerned that the impaneling committee that appoints a special prosecutor would be reluctant to remove him for violations of good conduct. You don't seem so concerned with having the Justice Department investigating itself, even the highest officials, the Attorney General or perhaps the President. And I wonder if, given that the concern that led to the creation of a special counsel law is that you would have, the highest levels of government being investigated, who you would hold this special prosecutor accountable to in such a way that you're not going to compromise any investigation. And you said, you talked a lot about how the law is unconstitutional. I wonder just how you could address that concern and change the law in such a way that you can still have a special counsel address that concern and make it constitutional.
With respect to the impanelment of an independent counsel by a special panel of judges, first of all, the judges are themselves unaccountable except for impeachment because they have life tenure under the federal system. The Attorney General or a president, of course, is accountable politically, as is his party, as we saw in 1974 when the Republicans went down big after Watergate. So there's accountability, there's political accountability, and that system has worked historically. It worked in 1924 with Teapot Dome. It worked with President Truman when he fired his Attorney General because his Attorney General turned around and fired a special prosecutor. It's worked historically. And it seems to me that you can insulate the system in a way which permits the individual, as I've suggested earlier in a legislative proposal I sort of mentioned earlier, to have them approved early enough so that they are out of the picture politically and can be brought in the case of where needs exist. That way, there is accountability both to the counsel as well as to the political figure involved.
Gordon?
On the first part of your question, the civil liberties point, the fundamental idea here under our rule of law is that all people are equal before the law. It seems to me outrageous that because someone serves in the executive branch, he should give up his constitutional rights to be treated equally under the law, and that's what's going on here. And there are several individuals out there, metaphorically speaking, lying in a pool of blood with a lot of attorneys' fees, some of them facing jail sentences. I mean, really, the most outrageous violations of individual rights that I think we can point to in this country during the last 7 years. On the other point, what do you do about it? I do disagree with what Tom says. I think that it would be a mistake to try to make the system work somehow more efficiently if we think that that's going to lead to a better system. I think that the way to get high-ranking executive branch officials to behave without the slightest taint or appearance of impropriety is to make it quite clear to the voters that the executive branch, as the branch charged with prosecuting people, has an obligation to prosecute itself. If there are a lot of rumors swirling around that there's something rotten going on inside the executive branch and there's not a prosecution, then the voters will express their views in the way voters do. And it seems to me to be a much greater disincentive to cutting loose with the law or other things that we've seen in past administrations than the current system that in fact lets the executive branch off the hook by throwing a few bodies to the sharks. But I can't really see whether you're nodding your head or shaking your head or throwing something at me. But
I am a little troubled that Mr. Boyd thinks that apparently that if ordinary people commit crimes, they should be subject to prosecution, but if high officials commit crimes, they should just be voted out of office. And you still haven't answered my question about...
I think that's a...
I don't think that's what I said.
Well, you haven't answered my question. How would the law be
mine.
Constitutional? What specifically would you change about the law to make it constitutional?
Well,
you support a law as long as it's not constitutional.
No, I don't support a law.
No, I meant Mr. Boyd.
Do I support a law as long as it's constitutional? Yes.
I know, but how would you change the existing law to make it constitutional? In your eyes, you apparently
Ultimately,
think it's
the
not
president has to be in
now.
control of the prosecution. We feel that's constitutionally mandated. There's no way to get around that. If you accept the postulate that the courts can appoint inferior officers, to go back to that phrase, then you have to accept the argument which was put forth by the attorney attorney for the House of Representatives during the Court of Appeals argument, and that was that Congress could delegate to the court the power to appoint the Solicitor General of the United States. Now, the Solicitor General of the United States speaks for the government of the United States. That would mean that the President would have to appear before the Supreme Court as an amicus or a friend of the court. It's ludicrous. We feel that you just simply cannot manage a criminal investigation. In the cases which Phil alluded to earlier, the Seabold case and Humphrey's Executor, neither of them involved criminal prosecutions. And we feel that that is the crux of the matter. That is a fundamentally executive function. And there's no way to get around that. So you have to have a presidential appointee in our judgment.
Gentlemen and guests, I'm going to abandon my role of moderation and take some decisive action. The hour is getting late, and I have two questions to ask before we adjourn. One, when I was first admitted to the bar, a friend of mine described lawyers as probability merchants. And each of you know that this case decided by Judge Silberman will be before the Supreme Court ere long, or before 8 justices of the Supreme Court. What is your forecast on whether the constitutionality of the present Independent Counsel Act will be upheld? Tom?
Well, with respect, in light of the fact that the Court of Appeals has ruled the statute unconstitutional, we only need 4 votes. I'll take 4. Judge Kennedy would have been a nice 5.
Phil?
Silverman will be reversed and the statute will be upheld 5-3.
You heard it first here, folks. Gordon?
There are some justices for whom separation of powers arguments make a lot of sense. That helps Judge Silberman. There are other justices, and a couple of them overlap, for whom civil liberties are very important. The result of this is that it's going to be decided 8-0 to uphold Judge Silberman's ruling.
Fred, do you have a forecast?
Phil's right.
Now, while we don't ordinarily do this at our forum proceedings, I'm going to just take a little poll. We did have Bruce Babbitt here during the Marvin Kalb series, who asked people to stand up if they were in favor of more taxes. I'm going to put the question to you that we had at the head of the program, independent counsel, prosecutor or persecutor. How many think that the independent counsel's office is a prosecutor's office? Any think contrary-wise that it's a persecutor's office? With that, we'll adjourn. I want to thank our panelists for a very illuminating discussion, and thank you for joining us this evening.